This is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory? All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the gun holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information, that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have no unsupervised time with the child. Are they still together?
No, this happened last year. So they co-parent. I talked to her last week. So she said she didn't want the no contact. So that was our issue. Because I talked to her and she was like, she doesn't agree with that because they co-parent well and she's in school. So he has the child while she's in school. But Mr. Coleman said he talked to her in June. And so she did tell me, she said, well, at the time they weren't on very good terms. So she might have told Mr. Coleman she didn't want. But now she said they are on good terms. And so that was our issue, you know.
I've got notes in my file contradictory. I'm not doubting what
She
Ms.
said,
Holmes'
yeah.
version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year
with the
ago.
complainant.
Okay, so the
And
August
she's
of
not the
24.
complainant. She had nothing to do with
She's
this.
not.
Well, mother of the child.
Yeah. So she had nothing to do. Like she wasn't on the scene.
Well,
she wasn't.
Is she
Since
here
we're doing
by
a lot
No,
of
chance?
she's
this-
not.
Since we're talking a lot about extraneous things, Judge, and what other people said, I'm saying, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her. So,
But you haven't heard anything since then?
no, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still in, you and the mom aren't in a
we are not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay, so let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been, and then, have you been receiving any treatment for any diagnosis
I did
that
go
you?
to spinal tap and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that regularly?
No, ma'am, not currently.
Well, that causes me concern. So,
I haven't been on it in more than 6 months.
why?
I'm having transportation issues getting back to spinal tap.
Okay. How do you get your child and?
My baby mom will drop him off to my house.
Right here's the turning point. Supervised visits only. The judge isn't taking chances when a child's safety and mental health concerns collide. No matter how calm the defense makes it sound, the court wants proof before trust is restored. Fair call or too harsh?
Okay, you're gonna have to go to, because of the nature of what you're saying that happened, and even though if she was under the influence, if there was some threats that had to do with that and some mental health issues, then at least and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to spinal tap when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's gonna be a part of your probation now. So you need to figure out a way to get there, you need to figure out, they'll help you with medication, whatever it is. And, I wanna know what you're on, what you're taking, and that you are following through with everything, so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, you're gonna be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, but your mom.
Do y'all didn't do paperwork already though?
I have it here.
Okay, I'll hold it while y'all get that
So
done.
what
I'll
do you want me
recall
to
it.
Because I didn't put as far as the agreed recommendation, him having no contact with his.
You don't
child.
have to put it as an agreed recommendation. I'll order it.
No
if you-
contact?
Judge, what I intended with the state, I recognize for the purposes of child exchange, there has to be some type of working.
Oh yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part. So I'm not going to order no contact with her. I'm going to order supervise with the child, because it sounds like that is what the underlying offense had to do with, not her.
Okay.
So y'all can either agree to mark it off, or I'll do it when it comes through. If you want to argue for it, that's fine, Mr. Coleman. But no, I'll allow him to have contact. You can have phone conversations with your child. You can FaceTime between now and then. I just don't want if there's a supervised, y'all can if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something.
The judge draws a hard line. No unsupervised visits with the child until proof of treatment and compliance is on the table. That's not just caution. It's the court sending a crystal clear message. Parenting is a privilege, not a right, when safety is at stake. But here's the tricky part. His co-parent says they've been on good terms and managing without issues for a year. So, is the judge overreacting or playing it safe? What would you decide if you were in her seat? Drop your thoughts below.
No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense? Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue. But I would say it's not going to be at her house. I want y'all to be somewhere public. That's not a good idea. Okay, y'all go take care of that paperwork, and I'll take care of it. Y'all.
Do I put as a condition, as a probation condition, supervise it, or?
No, because that's gonna be a bond condition.
Yeah.
I'll say it when y'all come back up.
Okay, so I won't write it in. Okay.
Yeah. Just have a seat. Yeah, y'all can go over that paperwork, and then I'll recall it in just a minute.
This is the forfeiture.
Okay, I just didn't know if you want to hold on to it.
Okay, on Roland Guillory. Again, you're Roland Guillory. And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Guillory, in cause number 24, DCCR 1568, the state is elected to proceed on the Class A misdemeanor lesser offense of attempted endangering a child from March 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Part of this agreement also is to forfeit the weapon, which I've already signed that order, and also to have psychological evaluation and to follow all of the recommended treatment. Do you understand? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Guillory is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to get a pre-sentence report done on this case. I am going to ask Kristen if this is something that you guys can kind of do in maybe 4 weeks instead of 6. But
Guilty plea entered, probation term set, and a strict bond condition of supervised visits only. The judge is giving him one last chance, but tying it to mental health compliance and documentation. This case shows us how justice walks a tightrope, balancing parental rights, child safety, and mental health realities. So what do you think? Did the judge strike the right balance, or was this too lenient? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And then we'll come back for sentencing. A condition of bond between now and then, a couple of things that we've already talked about, but now that we're going through this, I'm going to make sure everybody's on the same page, is that you're not to have any unsupervised visits with your child. That's so you can still have him do whatever like we talked about, so that I can get the pre-sentence report and see what's going on. Also, you need to immediately get an appointment with Spinal Tap. Hopefully you will have time to go to that appointment before the next court date. Bring documentation of anything you've done, any medication they've prescribed and things like that. And then at that court date, depending on what all that shows, then we'll get back to, at some point, I'm sure fairly quickly, you having your son again. But I just want to make sure everything is on track and that you are in a good position as well as your son.
Yes, ma'am.
Okay? You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? All right, we'll see you back at sentencing.